In this video, we're talking about defenses to possession of narcotic drugs. In another video, I explained what the law defines as narcotic drugs. In this video, we're talking about if you've been charged with possession of narcotic drugs, what are some common defenses? How do you defend against that charge? And it really boils down to three different sections. One, we're going to talk about possession. Two, we're going to talk about identification. And three, we're going to talk about some other standard criminal defenses that may be applicable to your case. So first and foremost, let's talk about possession. It's the first part of the statute, and it's probably the most important. It comes down to whether a person was actually in control, whether they had dominion, whether it was something that they had knowingly and were willingly in possession of. But it's not as clear as that. The law defines it under Arizona 13105, defines possess as knowingly have physical possession or exercise dominion or control. So in some cases, this can be a very easy type of obligation for the government to meet. A person admits it was in my hand, I had it, it was in my pocket, I knew it was there. So that can be a pretty clear-cut type of possession argument. But in most cases, it's really not that cut and dry. A lot of the times, people don't know about things being around them. A lot of the times, stuff belongs to other individuals. And if it is in kind of the purview of somebody, does that mean that they were actually in possession of it? Did they knowingly know that device was there, or that piece of a foil, or that needle, or whatever it is? Did they know it was there, or did they have control over it? Was it theirs? Was it in their purse? Was it in the glove box? Was it in the trunk? There's a lot of variables there that are subject for ripe arguments. And so proving possession is not as just simple as saying, well, we think that individual had it. It really comes down to, does it meet this standard? Possession, it's a voluntary act. Defendant knowingly exercised dominion or control. And dominion means it's kind of within their dominion. It's within their purview. It's within their bound of control. And so there are a lot of arguments that can be made there. A lot of these cases are kind of hinge on this, but it is very fact specific. You need to talk to everybody who's involved. You need to see what you said to the police and make sure that this is something that can be argued. In many cases, it can. Once we've moved past the possession defense, we go on to the identification defense. So just because an officer believes something might be heroin, or they did a field test and it came back as positive for something that's a narcotic drug, doesn't mean that that is something that is admissible in court. So I have here BARD. That stands for beyond a reasonable doubt. You may have seen this in movies or in TV shows. Beyond a reasonable doubt is the highest standard of proof that the government has to meet in order for them to find you guilty or convict you of a crime. And every single element of this has to move beyond that status. So if there's any doubt, any reasonable doubt as to any one of these elements, then they cannot convict you. They cannot meet that burden. So just like with possession, if there's reasonable doubt, if a reasonable person can doubt that there was possession, that's a great defense. Same with identification. So as I said earlier, in the other video I talked about the very long list of different drugs that are identified in that statute. Here they have to match it. So they have to pick that drug and they have to match it to something that is prohibited, to call it a narcotic drug. In some cases that's easy, but in many cases it's not. So what they have to do is make sure that they have the proper testing methodology. I have that here as the first one. How are they testing it? Who's doing the testing? How long have they been testing it? Where is it being tested? Those are all common questions that can be asked. If they are testing it, to what degree of certainty are they able to claim that it matches? So remember, these types of tests, anything in science, is just really kind of a best guess. It doesn't absolutely make sure that it is 100% the item or the substance or the drug. It's within a degree of certainty. So they'll say it's 99.93% certain that it is what they say it is. But there's still doubt there. And so sometimes that degree of certainty is less, sometimes it's not. Sometimes how they come up and calculate that degree of certainty is not good. So there are arguments to be made as to that as well. Same, what about the quantity? So what are they testing? How much do they have? Do they have a big pile of something? Do they have just a little bit of residue or remnants? Is it available for the defendant to test? Can we have our own independent expert test it? These are all very good questions. And if we can't test it, well, how can we verify their claims? How can we build our defense if there's not enough for us to test? Same with the chain of custody. So once this stuff is impounded, or the police take it from the scene down to the crime lab, who is doing what? Who takes it? Who impounds it? Who pulls it? Who puts it into the evidence locker? Who takes it out of the evidence locker? Who does the testing? How do they do the testing? Who writes the results? It's all called a chain of custody. And if there are problems in that chain, that's a great defense because it can invalidate or undermine the degree of certainty to which the government claims they know what they're talking about. Also, contamination. So all crime labs, anybody doing testing in any crime lab should acknowledge that there is contamination. There's contamination all around us. And it doesn't differ from a crime lab. Now, they try to minimize that, but they can't absolutely eliminate it. So to what degree did contamination influence the identification of the drug in your case? Finally, who did the actual testing? So this comes down to personnel questions. Who was the person responsible for the testing? What are their credentials? What is their background? Are they qualified to do this? Do they have any bias? Do they have any ulterior motives? These can be good questions to raise in front of a jury to cause that reasonable doubt. Once we move past the identification, we then move into some standard kind of criminal defense issues that we see all the time. So let's say, for example, that this happened after a traffic stop. Was it a lawful traffic stop? Did that officer have reasonable suspicion to make that traffic stop? Or was it an illegal traffic stop? If it was illegal, then everything that the officer found in the vehicle afterwards is not admissible. It can be thrown out. It's called fruit of the poisonous tree. Same with an illegal search. The penalty for conducting an illegal search, if an officer went into a car or went into a home without proper authorization or proper legal cause to do so, everything that officer pulls out of there is now inadmissible. It's thrown out. It's called fruit of the poisonous tree. They can't do something illegal and then use what they found illegally against you. So those are some common issues as well. Same with Miranda issues. Sometimes we'll see some Miranda problems. The officers will basically begin asking questions when they should have Mirandized somebody, and that can cause a lot of problems. There can be issues with coercion, also issues with some officer malfeasance. What did the officers do? How did they do it? Were they breaking things or treating people improperly, or what happened in terms of how they were complying with their code of conduct? And also Brady issues. So Brady was a case that said, the Supreme Court said that the government has to disclose to the defense anything that's exculpatory or anything that might tend to show a person's innocence, including whether an officer has any disciplinary issues, any other integrity violations, or any other issues that would cause us to make a defense around that. So these are the three main types of defenses. As I said earlier, I could probably have 10 whiteboards and go into it, but that would be what law school is for and all of our years of experience. But these are the main things you want to look for. So if you've been charged with a possession of narcotic drugs, it is very important that you take this case very seriously. These are serious cases. They are felonies. They have major ramifications. Depending on what they're claiming happened here, it can result in prison time. So you want to make sure that you are taking this seriously. If you are speaking with attorneys, make sure they're at least aware of these defenses. If you would like to speak with our office about it, we do offer free case evaluations. We can sit down with you, make sure we can review the facts of your case, and talk about how these things may apply. Look forward to speaking with you soon. Thanks for watching.